We're so glad that you are here and have taken time out of your evening to join us for this Zoom. We're grateful for Greg and for his willingness to be our teacher tonight. And so as we get ready, we want to begin with a word of prayer. Would you pray with me? God, we are so grateful for this night and for this opportunity that we have to learn about this important topic. God, we know that every good and perfect gift that we have in our life comes from you, and we want to be the best that we can be at managing those gifts, especially for those who will be here after we have gone. And so we pray, God, that what we learned tonight could be applied and could bring glory to you and benefit those around us. We pray this in Jesus' name. Amen.
All right, everyone. Well, before we officially get started, I want to go over a couple of things about webinar and the format in which we are using to do this presentation. So you might notice that you might not be able to see your own little square, and that means that we also cannot see your little square. But that does not mean that we do not want to hear from you during the course of this presentation. And so there's many ways in which you can chime in or ask questions, especially during Greg's presentation. And so I want to point a couple of those features out. On the bottom of your screen, you should see a couple of things there. The first thing that I want to talk about is the Q&A function that you should see at the bottom. This is extremely important. There's a little Q&A, and you can type questions in there. And whenever you type questions, I, as the host for this meeting, will be alerted of the question. And whenever there is a moment during Greg's presentation where we have an opportunity for him to answer those questions, I'll stop him, and then we'll go through the Q&A and we'll answer those questions live. The second feature that we have is the chat. If you're going to ask questions, I prefer that you ask them in the Q&A, but you can also ask them there. This is also a space where, whenever Greg finishes his presentation, where you can say, thank you, Greg, or when Diane finishes introducing him, you can say, thank you, Diane, or thank you, Krista. This is kind of just a forum in which you can speak with the community here. You can also raise your hand. There's a little raise hand function, and it's just a hand. It's pretty easy to find. I think I just saw a couple people actually raise their hand while we were doing that. That is a great way for you to be able to get attention, and I can bring you into the conversation via the raise hand option. Us do the Q&A so that we can make sure to get through everything in a pretty quick fashion, but that is also an option there too. And so we want this to be interactive. We don't want you to feel like you're disconnected because we can't see your face. And so just wanted to make you aware of those options that we have via webinar. What I am going to do now is turn things over to Diane. So I'm going to promote Diane to a panelist. This will take just one moment. And then I will also make her a co-host so that we can see her video. And I am going to disappear and sit in the background now.
Oh, why? Won't let me start it. Sure.
If it won't let you start the screen, I've made you a co-host. I'll try that one more time.
Okay, yeah. It's not letting me go.
Well, if we can't see you, we can hear you just fine. So
okay.
If you just want to speak and maybe we can work it out during the break whenever Greg starts.
I'm happy to do that. So I just want to say I'm Diane Williamson, and on behalf of the Lakewood UMC Communications and Stewardship Committee, I wanted to welcome each of you to our Estate Planning 101 webinar. I wanted to welcome our featured speaker, Greg Cain, who has graciously agreed to share some great tips on estate planning with us this evening. And I'm going to tell you a little bit about Greg. Greg and his family have been longtime members at Lakewood UMC. He graduated from Southern Methodist University with a BBA degree and also graduated from SMU Law School. He was admitted to the Texas State Bar in 1981 and is a member of the Houston Bar Association and the State Bar of Texas. He has spent most of his career in corporate tax departments and recently retired from Service Corporation International. For the past 10 years, he's had a small law practice that focuses on basic estate planning, business formation, and probate. We want to thank you, Greg, for being here with us tonight. And now I will turn the floor over to him. Thank you so very much.
I think so. Hello.
Yes, sir. We can hear you. Go ahead. We can see you as well.
Okay. Thank you, Pastor Schuler, and thank you, Diane, and Pastor John as well. And thanks for the invitation to speak to you all this evening and share with you what I know about estate planning. I think the slide deck and the paper that I've prepared have both been made available to you. My plan is to go through the slide deck fairly quickly, make occasional references to the paper, and then leave some time for questions. And I think there's some closing comments from some folks at the end of our hour, and hopefully get to any questions that may come in during the presentation. So let's start with moving to page 2 about what a will is. Let me do this. I forgot to share screen, so let me bring up my, let's see. There we go. Okay. Now we'll start off by considering just what a will is. It's one definition that I found is it's a legal declaration of a person's intentions that are to be performed after death. It takes effect at death and it is revocable. And there are 2 basic types of wills: the ordinary attested will, which is what you would expect from an attorney and you're probably familiar with. The other is a holographic will, which is entirely in the maker's or the testator's own hand. There were, under certain circumstances, oral wills permitted in Texas, but they were abolished by the legislature in 2007. And I kind of got hung up on that concept. I'm not sure how you'd probate an oral will, but we don't have to worry about that. Each of the attested will and the holographic wills have different requirements for proving them in court. And that is necessary when you admit a will to probate and ask the judge to approve the proposed executor to serve. So now that we know what a will is, let's look at what who needs a will. Well, we can start by maybe considering who doesn't need a will. A minor, someone under the age of 18, cannot execute a will because they are still under a legal incapacity. They're minors. Instead, for a youngster, you use maybe a trust or a guardianship. Also, someone who isn't legally competent, other than being underage. Again, you might use a trust, a special needs trust, or a guardianship. And then generally anyone who is comfortable with the way Texas law works to determine how their probate estate will pass if they die without a will, which raises the laws of intestacy. So who needs a will? Well, someone who owns real property, because you need to get when the maker dies and that person's interest, say if it's a couple, their community interest, for example, passes to their estate. To get it out of the estate into the surviving spouse's hands will require the approval of the court, unless we use something else, which we'll talk about in the next slide. A parent with minor children should seriously consider a will. It's a good way to provide for your youngsters until they're of majority. And anyone with property that's held outside of beneficiary designation, you know, your retirement accounts, your brokerage accounts, life insurance, those kinds of assets will pass outside of probate by beneficiary designation. But if you have substantial property, a collection, art collection, other personal property, then you probably would want to think about having a will. If you die without a will, then again, the laws of intestacy, which are in the Texas Estates Code, come into operation. And that might work the way you would like for it to, but it might not, especially if you're in your second marriage. Then the results may not be what you would intend. So, will alternatives. Well, you probably are familiar with the Irrevocable Trust. That's frequently proposed as an alternative to a will. It does avoid probate, and it also maintains privacy. A will become public record when it's filed for probate. You file the application for the proposed executor, and then you have to file a copy of the will. I mean, you have to furnish the real will to the court within 3 days. So, and then it goes up on the county clerk's website for anyone to see. Irrevocable trust will also avoid ancillary probate for real property located outside of Texas. And if the decedent leaves property elsewhere, real property elsewhere, you'll probably have to contact local counsel to have that taken care of. It's also a way to achieve incapacity planning. Where an alternate trustee would take over in the event that the original trustor becomes incapacitated. You can couple that with the power of attorney for property that cannot be transferred to a trust, which is kind of a rare subset, but it can occur. But the thing about these trusts is they require careful management. You have to be careful that everything you acquire after the trust has been put in place is then transferred to the trust. Otherwise, it could pass outside of the trust on your death. So to address that, frequently irrevocable trusts are coupled with pour-over wills. But of course, then that introduces an instrument that has to be probated. So irrevocable trusts really are not that, I don't think they're that compelling in Texas. Texas probate is not that onerous. It's not that expensive compared to other states. But some people do want to go the trust route. Another alternative would be the transfer on death or pay on death. If you the way you set up your financial accounts with transfer on death or pay on death, but that still leaves the real property to be contended with. Which brings us to the last point here, and that's the transfer on death deed, which I'm sure many of you are familiar with or have heard about. Of course, this still leaves the personal property unaddressed, but it is a way to transfer real property without probate. There are some challenges to it, though. It's still a fairly new form. There is no current statutory form for it. There was one, but it was repealed in 2019. Deeds that use that form before termination or before it was repealed are still valid, and you can still use the form yourself if you want to. And then I give a site there where you can go in and take a look at the form. I've been told that some title companies may not be very comfortable with a transfer on death deed, however. Well, let's get back to looking at wills in a little bit more detail as to what they're comprised of. It, of course, is a written document that identifies the maker or the testator. The maker has to have legal capacity when he or she makes the will. That means being at least 18 years old or married or in the military. And mustn't be otherwise under a legal disability at the time of signing the will, and needs to be of sound mind. That's a term of art, which is explained in the Estates Code, how you achieve that. But that's usually not an issue. The document also has to show testamentary intent, that the testator intends that the document dispose of his or her property at death. Has to be evidenced in the written document itself. And courts will go to some length to find a document that's been presented to them valid. So they're not looking to ambush or shoot us down there. And the will should be dated. How about witnesses? Well, if you have a holographic will, it's not required. But then when that holographic will is presented for probate, you'll have to bring in, or your proposed executor or somebody in the family will have to bring in 2 witnesses who can attest to the maker's handwriting and signature in court. So the better practice when you make the will is to have 2 witnesses who are at least 14 years old, they're credible and disinterested, so they're not your kids and not somebody listed as an heir or alternate heir in the document. Sign the will and in the testator's presence. And this will be memorialized in what's called an attestation clause, which is typically placed at the before the witness's signature lines. And if you'll turn to page 7 of the paper, there's a form of an attestation clause lifted from the Texas Estates Code. But the preferred way to do this, and an attorney will furnish a will with this kind of provision, is to include the self-proving affidavit. There's standard language there. This is on page, I'm sorry, that's on page 7, the self-proving affidavit. It eliminates the need to bring witnesses into court, so this simplifies the probate procedure for your family. It's usually part of the document when signed by the testator and the witnesses, but it can be added later at any time during the lives of the testator and the witnesses. Well, now that we have the will, let's talk about storing it and safekeeping. On page 11, I've included of the paper a page that talks at some length about storing your will. Once it's complete, signed, witnessed, notarized, and ready to go, that's the time to make a copy before it's stapled together or stapled to the blue back that lawyers like to use. The reason for that is you really don't, once the document's been stapled, you don't want to take it apart. In the event of a will contest or any problem with the will in probate, it can be, the court will kind of examine the staple holes at the top of the document. And if there's only one set, it's harder for someone to allege that after execution, a page was removed and a different page was put in. Now, when you've got the will, you've got the original will should be kept in a safe place where it's easy to find. You want your family members to know where that is. If it's in a safe, make sure that the safe can be, well, if they know that, and it can be opened. And it's fine to make a copy. Like I said, the preferred time is to do that before it's stapled together. But if it's already stapled, just bend it back at the corner and make copies that way. But on the first page of your copies, please write the word copy. That will eliminate any confusion later when the will is probated. Well, those are kind of the high points on a will. So we'll now look at the first document in, what I consider kind of the basic portfolio of estate planning documents, and that's the statutory durable power of attorney.
Greg, before we get there, is it okay if I ask you one of the questions that has popped
Certainly.
up in the Q&A?
Sure.
So Colin McLeod asks, do you need to mention all children / possible heirs' blood relationships in your will, whether you give them something or not, or is this good form?
I think it's probably good form to mention all descendants. So that would be your children. If you've remarried, probably your spouse's children. even if they don't take anything, their will forms, templates have phrases that will include after born or after adopted children. So, you know, that everybody will probably be captured in one way or another. As far as listing folks that you don't intend to inherit from you, I think you still list them because they're still your children. The typical advice from attorneys on that point is it's probably best to go ahead and make a small bequest to even someone that you otherwise wouldn't want to share in your estate. That makes it a lot harder for that person to attack the will in a contest after you've passed.
All right, thank you very much.
You bet. So on the statutory power of attorney, this is a written instrument by which the principal appoints an attorney in fact as agent and confers on that person the authority to perform specified acts on behalf of the principal. And then I give a little cite there in the slides and the paper to the Texas statutes. If you're curious as to what all the Texas statutes that are in codes have been codified look like, you can go to that statutes.capitol.texas.gov. It's very user friendly and it'll take you right to where you need to go. But tonight we're talking about the Estates Code and the Health and Safety Code primarily. The statutory form, which is on page 13 of the paper, was promulgated in 1993. You don't have to use this form if you don't want to, but the advantages of using it are that it assures compliance with the requirements to be an effective power of attorney. And third parties, such as title companies, might be more willing to accept it since it will look familiar. Durable just means that it survives the maker's incapacity. At common law, powers of attorney terminated upon the principal's incapacity. And this is an important point. It can be made effective when signed or later upon the principal's incapacity, which is called a springing power. But most attorneys recommend the former, that you make it effective as of the date of execution. And that is the kind of the default treatment in the template form. If you look at page 15, you'll be able to see that. And some people say, well, I don't know if I want it effective now because, you know, my adult son might go out and do something I'm not comfortable with. Well, if that's the case, then you probably should have a different agent. Your adult son may just wait until you're incapacitated and do that anyway. So I don't think that's a very compelling reason to not make it effective upon execution. And then special rules do apply if the power is going to be used to close on the sale of real property owned by the principal. That's a relatively recent change to the Estates Code, and that's just for the public's protection that it has to be done in the attorney's office. You don't record these powers typically unless it is used to transfer a title to real property. Then I think it's basically assumed to be a real property document and will be recorded. The next document in our portfolio is the medical power of attorney. And I've lifted from the Health and Safety Code the form on page 18. And here, this form is essentially mandatory. In choosing your agent, you cannot choose a healthcare provider. And your agent will be able to make any healthcare decision with certain exceptions that the principal could make if competent. The agent will have access to protected medical records, which we'll discuss in another context here in a few minutes. But the agent must consult with medical providers when making decisions and must act in accordance with what he or she believes to be the principal's wishes, religious and moral beliefs. If not known, then in what is in the principal's best interest. For execution, the principal must sign a disclosure statement. That's on page 19. And if you look at that, that's quite lengthy. And again, this is just so I think for the public's protection, so that the maker is fully informed as to the scope of what he or she is executing. Must, of course, sign the power of attorney itself. It either has to be notarized or signed by two witnesses, at least one of whom must not have certain relationships to the principal as set forth in the Health and Safety Code. And all parties must be adults, 18 or older, and legally competent. It is effective upon a physician's certification that the principal is not able to make medical decisions for themselves. So medical powers of attorney have springing powers only, unlike the statutory power. And it terminates upon revocation by the principal, of course, or upon the principal's divorce if the agent was the spouse, but not upon the creation of a guardianship by a court, unless the judge finds that revocation to be in the principal's best interest. There is an alternative if you don't have a medical power of attorney. If the critical need arises and the patient has not executed one of these, an alternative is available under the Health and Safety Code. It's under the Consent to Medical Treatment Act that allows certain persons who are listed there and considered to be surrogate decision makers to act on behalf of a medically incompetent patient. So these would be family members and people that we would expect to have that kind of latitude. Well, the next document we will look at is the Directive to Physicians, or the Living Will. This document rests upon a person's right to refuse treatment. It's aimed at the situation where a person's wishes regarding life-sustaining treatment are relevant, but that person is no longer able to communicate. Let's say they're in a coma. The Texas Health and Safety Code provides a model form, which is included in your paper at page 25, but this form is not required, not mandatory. So Texas follows what's called the substituted judgment standard here, which means that the directive isn't required to terminate life support, and that decision can also be made by an agent under the medical power of attorney, a legal guardian, or a court-appointed guardian of the person, or someone so authorized by a Health and Safety Code, which again, this is a close family member like the spouse or an adult child or your parents, the parents. But having a directive kind of simplifies things and makes the maker's wishes clear. Now, these directives really address two situations. They apply to people who have a terminal or irreversible condition that has been diagnosed and certified in writing by an attending physician. Terminal is defined as an incurable condition that is likely fatal within 6 months. Irreversible is defined as incurable and rendering the patient unable to make their own decisions, but not necessarily fatal within 6 months. So this could be a vegetative state, a coma type situation that could go on for quite a while. The medical directive allows the maker or the patient to address these two scenarios separately. So you can look at page 25, and the choice that you make here essentially is, do you want life-sustaining services to be continued, or do you want them to be withheld and you be kept as comfortable as possible and be allowed to pass away as gently as possible? And you can address each of these situations separately. You can choose one path for one condition and the other path for the other condition. These directives can be made orally as long as it's in front of an attending physician and 2 witnesses. And if written, it must be witnessed by 2 adults, at least one of whom has no family relationship to the maker, or notarized. And they can be revoked orally, or of course by destruction by the document itself or a superseding directive. And the patient's competence at the time of revocation does not have to be proven. So they can just decide to tear it up. A person, such as a physician, must have actual knowledge of revocation in order to be held liable for not acting on it. So that's for the protection of caregivers. The next document we'll look at is the DNR, Do Not Resuscitate Order. This again is authorized by the Texas Health and Safety Code. This is typically an out-of-hospital instruction, maybe given to ambulance paramedics that a person, and in it the person will say that they do not wish to receive cardiopulmonary resuscitation, defibrillation, or other specified treatments. It can be oral or written. If written, it must be signed by 2 witnesses or notarized, and it must be signed by the attending physician. And if oral, it must be made in the presence of 2 witnesses, and again, in the presence of the attending physician. And because of that attending physician requirement, DNRs are typically not part of an estate plan. It's similar to a directive to physicians or medical power of attorney, but differs in that it can be issued following the principal's incapacity by way of a physician in accordance with the principal's directive, if one has been prepared, or the agent in accordance with the principal's power of attorney, if that has been prepared. So a directive to physicians is typically prepared beforehand and by the estate planning attorney. The DNR is usually prepared at the time of the medical event and is usually done by a healthcare provider. And the physician is requested or required to make the DNR part of the patient's record. The next document we'll look at is the HIPAA release, the Health Insurance Portability and Accountability Act of 1996. I'm sure you're familiar with this in general. It authorizes the release of protected health information to designated individuals by a covered entity. There are a lot of terms of art that are defined in this area. A covered entity includes a health provider, a health clearinghouse, such as a medical billing office, and a healthcare plan, such as Medicaid or Medicare. And it's governed by the Code of Federal Regulations, and there I give the site if you would like to go read it. Well, you might ask, after what we've looked at so far, are these things really necessary? Well, the professional judgment exception says that a covered entity can use professional judgment to make disclosures if in the best interest of the patient, even if the patient isn't present or has consented. Example would be a pharmacist releasing a prescription to a third party. So you go to CVS and pick up your elderly parent's prescription, and they know you and they give it to you without any problem, even though it may reveal what your mom or dad is being treated for. But not all providers will be comfortable relying on the professional judgment exception, especially if more consequential or intimate situations. And a HIPAA release would cover those. So, well, you might ask, well, can the medical power of attorney cover this? Well, yes, if the patient is incapacitated. Remember, they only come into effect under their springing power once the physician has certified that the maker is medically incapacitated. But no, if the patient is still legally competent. And a physician may be reluctant to tell the agent of the patient's medical condition without a HIPAA release. So you could have kind of a circular problem there. And more practically though, the client may, or the maker may wish to allow more people than they have named as agent in a medical POA to have access to the medical information, all of their adult children, their spouse, and they can list all those folks in the HIPAA release. So the HIPAA release is typically included in the estate planning portfolio, even though the medical judgment rule could make it superfluous. And it's one more document that you have to keep track of. The federal regulations list a number of requirements for a HIPAA release to be effective, and the model form on page 30 of the paper sets those out. We'll now look at two declarations of guardian that you may want to consider. The first is declaration of a guardian in the event of later incapacity. This would typically be for you. A person who is not incapacitated can execute a document naming certain persons to serve as the guardian of their person or their estate. So I've included at page 33 a copy of the model form from the Estates Code, but that is not mandatory. The maker can also state in the same document people that they do not want to serve as guardian of the person or the estate. And this is all relevant because in the event of a guardianship, that will require that you go into, or that your loved ones go into court on your behalf, and this document will be presented as you nominate people or the person that the maker wishes to serve. Now, it's typical for the maker to appoint the same person to serve as guardian of the estate that they have appointed to serve as agent in the statutory power of attorney, and the same person to serve as guardian of their person as they've appointed to serve as agent in their medical power of attorney, but that's not required. And if these are not made entirely in the maker's own handwriting, they have to be witnessed by two credible persons, 14 years old or older, who are not named in the documents and must be notarized to be self-proved. The second document, guardian declaration that you may want to think about is really one you would make on behalf of your kids. A parent can designate a person to serve as guardian for minor children. The model form is on page 35 of your paper. And again, it's not mandatory. And this can also be done in the will, but the advantage of doing it in a separate document is it takes effect upon the maker's incapacity, and you don't have to wait all the way until they're passing. So that's a clear advantage there. Disadvantage is it's one more document for the family to keep track of. But I don't think that's a really compelling argument against creating these documents. If it's not entirely in the maker's handwriting, it must be witnessed with the same formalities as a will. Two credible, disinterested witnesses, at least 14 years old, and notarized to be made self-proof. Well, now we'll look at two documents, considerations you may want to think about end-of-life type issues. The first is making anatomical gifts. Well, I discovered that probably the best option for doing this is on what's called the Glenda Dawson Life Texas Registry, and you can Google that. I discussed that up earlier in the handouts in the will section. This is maintained by the Texas Department of Health Services. But under the Health and Safety Code, you can also declare your wishes to donate organs and tissue in your will, but that's obviously not a very good idea because the will usually doesn't come of front of mind until sometime after you've passed. Or on your Texas driver's license, which is probably where most of us have done that, or identification card. It can also be done during a terminal illness or injury of the donor by any communication witnessed by at least 2 adults, at least one of whom is disinterested, or by completing a donor card in accordance with the Health and Safety Code's provisions. So you can see that the state has gone to great lengths to try to make this possible. And the last thing we'll talk about in the way of our documents is disposition of remains. You can appoint an agent to control the disposition of your remains, including cremation, and that's permitted under the Texas the Health and Safety Code, and the model form is on page 38 of the paper. That person, and in the absence of such a document, people named in the code in the order that is shown in the code, starting with the spouse, have this authority. But understand that they are also responsible for the interment or inurnment of the remains, and they're responsible for the reasonable cost of that service. But that can be reimbursed from the decedent's estate. And of course, you can do this in your will, but again, that's probably not a very good idea. Or in a prepaid funeral contract can be used for this too. And that is the end of our high-level review of estate planning documents, Estate Planning 101. And
Great.
We can go into the questions I've received, or we can go to any that may have come in the meantime.
Yeah, Greg, we've got a couple that have been submitted even in the last couple of minutes on here.
Okay.
About 6 or 7. So let's go through these really quickly. The first one, how often should a will be reviewed and or updated?
Well, I think when there's a major life event, that's obviously an occasion for review and updating. I've heard that maybe we should look at our wills every 10 years, which means mine is coming up. But I've probated wills that are older than 10 years, and they've gone through fine, as long as they've been executed with the formalities that we discussed earlier this evening. Updating a will, that suggests that somebody's thinking about just maybe adding an amendment, which we call a codicil, to an existing will. And that really, I think it's better just to redo the will and incorporate the changes in your new will. But it's really kind of just whatever you're, I think just be comfortable with. I think most of us have enough changes that come along in terms of kids being born and grandkids being born, and maybe we've changed addresses and things like that. Not that that's really that critical, but every few years it's probably worth looking at it and seeing if it's time to update or replace it.
Great. Next question. This is a 2-part question. When is it advisable to establish a trust for an estate, and what would the advantage be to do so if you have a will?
Well, we talked about trusts as alternatives to wills. Trusts can afford certain creditor protection, a spendthrift trust, for example. They also afford privacy that a will does not. If you have a will and you're comfortable with that as your principal estate planning document, I don't think you also probably need a trust unless you want to establish one for your children. And that, can, like I said, can be done in the will. But trusts are taxpayer. They're not necessarily taxable entities. A revocable trust is usually a pass-through trust, which means the activity within the trust is passed out to the trustor, who reports that on his or her own individual tax return. But it's still a compliance requirement. And if the trust is taxable, the trust, I haven't looked at this lately, but the trust tax rates, I think, are quite steep. And it doesn't take much taxable income to reach the highest marginal bracket. So trusts have their place, but I'm not sure that in estate planning, they're really all that compelling.
Should the deed of a home be changed after death of a spouse when the will outlines how said property would be handled in case of death?
Well, I think you're if the whole home was community property between husband and wife, and one passes, then that person's community interest goes into that person's estate. And to get it out of there and into the surviving spouse's hands and clear title, you have to probate the estate, unless it was in a transfer on death deed. So I think you still need to probate it. I have to look at the document itself to probably give a more informed answer. But probate's really nothing to be afraid of. It's really not that difficult. Well, when it becomes complicated is when you have more than one heir. But it's typical husband-wife situation where the surviving spouse inherits everything. That's really pretty straightforward.
Which of these documents must be executed by an attorney versus using online apps and documents? For the latter, how are they made legal?
Well, that's kind of the client's call. I think that basically they should all be prepared by an attorney. For one thing, that way you have someone to hold responsible for what's been done and given to you. Could you repeat the second part of that question there, Schuler?
Yes, sure. For the latter, how are they made legal? And legal is in quotations.
Yeah. That's an interesting question. Well, they're made legal. Well, they're made legal. You can assume that they're legal if they've been prepared by an attorney who's a member of the state bar. If you pull one off of LegalZoom or something like that, and they're probably okay. You could line it up against the templates that are in the paper and see if it's got the features and if it's it's got the places for witnessing and notarizing. And if it mirrors that, then you're probably okay. The will, which of course we don't have a model form for the will in there, as long as it's notarized and it's signed by two disinterested witnesses, and there's some other terms of art that should be in a Texas will to facilitate probate, like you want to declare that your proposed executor serve independent of court supervision, that he served without bond. And I'm giving away all my secrets here. If you don't do that, it can complicate things for the executor. I probated a will from a gentleman here in our neighborhood a couple of years ago. It was for his mom, and I think they'd gotten it off the web and filled in the blanks and all that. And it was valid, but it was not witnessed. So we had to find two witnesses who knew this elderly lady's handwriting and signature, and then have them come. This was before the pandemic, so they had to be willing to come downtown to the probate court and participate in the hearing. And if an attorney had prepared that will, it's highly unlikely that that would have been necessary. So, you know, you can do it if you like, but especially for the will, I think there's some risk involved.
Are there any federal or state tax consequences for willing property or cash to heirs?
Well, there are. Of course, the exemption for the state tax is like $11.5 million per person. And through a device called Portability, it's possible through planning to shield from federal estate tax a taxable estate of $25 million. Or $23 million, I guess. Income tax is probably what most of us are not going to trigger. The vast majority of Americans will not trigger the federal estate tax. Texas does not have an inheritance tax, so that kind of tax is not really an issue for us. We'd be concerned about income tax. Still, you know, one of the kind of the nice things in the Internal Revenue Code still is the step up in basis for inherited property. So if you or your loved ones inherit stock or something of low value, I'm sorry, low basis, but a high value, it steps up to current market value at date of death. There's an alternative valuation date, but essentially the same. And that's a sweet deal, but I will tell you, I think that is at risk right now with the current administration. So stay tuned on that point. But passing property is not usually a income taxable event. It's an asset. If you know, the fruit of the tree analogy you hear in law school. The tree is not taxable, but the fruit it produces could be taxable. So if you give somebody an asset itself that may not be a taxable transfer, but as that asset throws off taxable income, somebody's going to pay tax. So my cat just joined me, and she wants to eat, I think. So I'll try to keep her out of this meeting.
All good.
But
next question. Go ahead.
Yeah.
Sorry.
I think I'm tapped out on that one.
Okay. We'll keep rolling through these. Greg, how many questions did you have pre-submitted to you? Because I want to make sure we get to those as well.
Well, I had 6. I think we've actually kind of touched upon a couple of them.
Okay.
Let's see. Trust and will. Lucy. Okay. Lucy's going to feed the cat, so we're good. This is a very good question. How do you find an executor when you have no capable friends or relatives? And what do you do when the will needs updating? We talked about that. But that executor question is that's a tough one. Because being an executor is no cakewalk. It's usually the executor is somebody that's also an heir. So they're interested in having it done properly, and they one of the things I was going to propose is you can provide for compensation to your executor, but if they're also an heir, they're just taking it out of one pocket and putting it in another. So, and the provisions under the estate code for compensation are not they're not very rich. It's I think it's like 5% of cash distributed or collected you can keep as a fee, and usually there's not a whole lot of cash involved in a will, but you can provide for something else as well, something that should be reasonable and defensible against if there's more than one heir, then that's where the tension may come in. You can also name an institutional executor to serve as a fiduciary, corporate fiduciary, but that would usually require a fairly substantial estate to justify that kind of expense. And let's see. I think we've talked about this one, power of attorney, trust. Yeah, I think we talked about that one. A durable power of attorney. I have a durable power of attorney, which I have, my daughter is the agent. I have a statutory power of attorney. Last will, leave everything to my daughter. If she cut, well, this lady said she listed all the documents we talked about tonight, and she asked if she's covered, and I think she essentially is, unless she wants to consider the declarations we talked about. And then she says these were prepared 18 years ago. So that kind of raises the replace or update issue that we talked about earlier too.
Great. I have a couple more. I know we're getting close to 8, but I think we can get through them pretty quickly, hopefully. One of the questions is it still considered a good idea to be sure your family knows your wishes to donate your organs, since the police might have your wallet in case of an accident?
I think so. Absolutely. And I think I'd have to look back at that slide, but I think your family would be one of the designated authorized agents under the Texas Health and Safety Code to make those wishes known. So yes.
All right. Next one. In a will, what changes or additions can be made in a codicil? You might share what a codicil is and what is a legal codicil. Are there any requirements to prove up the codicil? Does it need to be notarized or have any other witnesses to prove up? I can repeat the series of questions.
Well, I have recent experience. I think that was written by somebody I know. I have recent experience on this point, and a codicil can change, I think, essentially anything in the will. And it really should be executed with the same formalities as the will itself, which means it should be witnessed by 2 qualified witnesses and notarized at the time of signature. And if it's not, then you're going to have prove up, you're going to add to the prove up task list for the executor and for his or her attorney at probate. So yeah, if you have just one tiny little change, like there's address misstated or something like that, you can use a codicil. But again, a codicil is I don't know how much attorneys typically charge for codicils, less than for the will, but it's not. If it's a substantial change, I would consider just replacing the will.
Okay, 2 questions on transfer of death deed. Is the deed form for transfer on death while not approved be recognized by state? And the second part of that is the transfer on deed death. The form was rescinded, but will it still be recognized in court since it was still recommended?
I think it will still be recognized in court. I think the critical question is, how will title company feel about it? If that's the way the heir acquired title from the deceased property owner, and it's recorded, of course, and everything. I don't know if the title company is going to. I'm not a real estate lawyer, so they're valid, but I'm not sure yet how effective they are. It will be recognized by the state, and it's right. I think it would be recognized by a court, although I'm not really sure the scenario where a court's review would come into play, because it would pass outside probate.
How does it work when assets are willed to a minor? Who oversees them until age of majority? Does this need specific language in a will?
Yeah, I think, well, if a minor cannot inherit, I don't believe, cannot accept legal title. And I really am not very experienced in that scenario, but I would, if I were presented with that kind of of situation, I would look at the Uniform Gift to Minors Act. I would look at guardianship's fairly. I think there are probably things you can do that are short of something as complicated and expensive as a guardianship, but probably the UGMA, something like that. Yeah, that's what I think. That's probably what I would look at first.
All right, the last question that has been submitted in the Q&A. Could you mention step-up value of assets?
Well, they're asking, did I mention or could I mention step-up value of assets?
Yeah, it says, could you mention step-up value of assets?
Well, that's simply a provision of the tax code. I think it's section 1014. I forget exactly, but where when you inherit, the best example is stock. If you inherit, like a brokerage account, then let's say the stock has a $10 basis, which is basis is cost. That's what the stock, the owner paid for it. And let's say now it's worth $50. On death, under the tax code, it steps up to $50. So $40 of gain is you don't pay tax on that, and tax is never paid on that. And that's really what step-up basis is, but applies to all, not just stock. So it's most property is going to depreciate. So if you inherit a car, it's not going to be worth probably what was paid for it. But other assets, collectibles and things like that, could have a value in excess of cost, and there too, the value steps up to fair market value at date of death.
All right, Greg, that is all that I have for the Q&A. I want to turn over to you to see if you have any closing comments before we turn it back over to Diane to close. I
have none. I thank you for the opportunity to share what I know about estate planning with you, but I especially thank you for participating and for we just have a wonderful church. You've got some great friends out there and wonderful clergy leadership. And I thank you very much.
All right. Thank you very much, Greg. Diane, if you want to go ahead and unmute, and we'll see if you can turn your video on this time.
All right. Fair enough. Oh, gosh.
There we go.
Okay, here we go. Well, I just want to thank everybody who's able to join us tonight. I hope Greg was able to answer most of your questions and that you have some great new estate planning tips that will be helpful to you. This webinar, we've recorded this and we will post that on our website, the Lakewood website, which is lakewoodumc.org. And we'll have the website if you want to view it again or tell your friends about the information. And we'll also have the documents that Greg had shared with us. The PowerPoint presentation and his more detailed document will be on there as well. So that will be there for your viewing. And I want to thank Greg again so much for doing this. We're very thankful for all the information and all the time and preparation that went into this. So many, many thanks to you and also to the great staff at Lakewood for helping make this webinar possible. So thanks again, and let's bow our heads in prayer as we close. Heavenly Father, thank you for each person who is able to join us tonight. Thank you for the amazing technology that allows us to share this important information with others in their very own homes. We ask for your wisdom as we use these tips to better plan for our families. Bless the families represented here tonight and be with each of us as we leave here. In your precious Son's name we pray. Amen. That's all I got. And thank you again to everybody for being here.
Thank you, Diane.
Okay.
Bye.
Bye.